Here we are talking about a topic which is, I might say, quite close to my heart. Essentially, we are discussing European law. Now, given the context that right now, when this is coming out, it is Brexit talk negotiations going on, and we've been hearing all kinds of knowledge and information coming out of Juncker and David Davies, and indeed Boris Johnson about the way going forward. All this is about really competition and how Britain can stay competitive. Which links in to the question we're going to have today, which is focused on European competition law. Here's the question. Now, competition lawyers must understand economic concepts, and competition economists must understand legal processes. It is common practice today, and much to be welcomed, that competition lawyers attend courses on economics and vice versa. Possibly a apocryphal story is that a competition lawyer once remarked at a competition law conference that, in his view, in any competition law case, the lawyer should be in the driving seat, and that a competition economist readily agreed, since he always preferred to have a chauffeur. Now today, it is better to think of the two as co-pilots. That's a quote from Wisham Bailey's competition law book, dated 2015, 8th editorial. The real question we're having here then is, can we, as lawyers, fully comprehend the jurisprudence relating to Articles 101 and 102 of the Treaty of the Functioning of the European Union without some understanding of the economic terms involved? Now, for those who don't necessarily know, Articles 101 and 102 relate primarily to the terms of competition law in regards to non-competitive practices. You might think of the Sherman Act in the US, but when we're talking about the EU, it's Articles 101 and 102, possibly Article 106, but 101 and 102 focus on matters such as concerted practices, monopolies, oligarchies, essentially situations where a company's in a position of dominance and they try to take advantage of that position, and what the law can do to curtail that irresponsibility and make them more competitive so as to give a better all-round system for the consumer. So the more competitive the businesses are, the better we are, which fits one of the pillars of the European Union in regards to competition. Now, in regards to how I've structured my answer, I focused on the idea of economic terms. You've got to keep in mind the question itself asks whether you can understand the jurisprudence with economic terms, whereas the quotation we just received from Wisham Bailey talks more about economic concepts. And there is a distinct difference, which hopefully will be revealed over the course of this discussion. Now, we'll start here. Wisham Bailey, in their book on competition law, discussed the great value in lawyers learning economic concepts in modern times, and economists doing the same so that they are co-pilots in the development of European competition law. However, Wisham Bailey also mentioned this was not always the case, when they remark the lawyers were once in the driving seat and the economists just along for the ride. Content to allow lawyers to develop competition law. This shows that there was a split earlier on, and indeed that lawyers likely took the lead. The question then is whether a lawyer, without knowledge of economic terms, can still understand fully Articles 101 and 102, which focus on competitive practices. What is important to stress at this stage is that while our lawyer is assumed to not know economic terms, that is not to say they do not know economic concepts, which is where the real understanding of the law takes place. To recognize the difference, let us use Adam Smith's idea of demand and supply. From looking at an economic dictionary, demand is the need for a product, supply the provided item. But demand and supply, when put together as a concept, means something very different. It means that there is a buyer and there is a seller, with prices fluctuating on the product depending on the balance between the two. So if you have greater demand than supply, obviously the price of your goods should realistically increase in price because more people want it, so they'll be willing to pay more to receive it. Equally, if there's more supply than demand, the product should cost a deal less. Now, when this example is applied to the question, what is being really asked is, could a lawyer who understands the theory behind the economics, so our demand-supply concept, could they still comprehend Articles 1 and 1 and 2 despite not knowing what the economic terms used in them might mean? The answer to that question lays ahead. And in order to answer it, those economic terms must first be identified. Here they are. So we find in Articles 101 and 102 the terms undertakings, concerted practices, trading conditions, control production, market share, competitive disadvantage, supplementary obligations, economic progress, dominant positions, so forth. Some of these economic terms were included initially, such as our concerted practices and undertakings. Others came in over time. Now, with those initial wordings, we also found our early European lawyers and justices running into dilemmas of how to interpret them, or indeed how to understand them. One such example becomes clear in the case of Continental Can, which was in the early 1960s. Now, to understand, Continental Can was a case which demonstrated that economic terms, or their pre-existing meaning, is no guarantee of understanding how they would be used in EU competition law. The case itself was considering a situation of a merger, which constituted the establishment of a dominant position. So imagine in this country if, say, the Mirror, which controls a large share of newspapers, was to merge tomorrow with the Telegraph or to merge with the Sun and News Corporation, Sky News Corporation, all that. You would end up with a newspaper that is perhaps 60 or 70% of the market share, so a real dominant position. This is a situation like that, a merger that was creating a very dominant business. Now, in this case, both the Advocate General, who was talking on the case, if you don't know who an Advocate General is, think of them as a senior barrister or justice or someone who has a great deal of skill and knowledge in this area that might give advice on the situation and will give their own view on a case. Usually this would come out before the case itself has been decided, and they might not necessarily be involved in the process of designing the case. In any case, our advocate, as well as a number of US economists, after reading through the terms involved, such as dominant position, they strongly held the belief that any company which stepped into this dominant position in the market would immediately threaten a monopoly and thus had a potential to exclude competitors, and was in effect in a dominant position, and so was infringing on competition practices. Now that's what they thought. So if this case had been decided in America, the situation would be, yes, this merger created a dominant power, so it should be prevented. However, the European Union is not the same sort of machine. And indeed, they took a different stance in this situation. as the justices themselves, quite in spite of the established economic terms, began to set out the circumstances for establishing dominance, which the Commission did not question. Now, this is very important because at this point in time, you could say our justices did not understand the economic terms at play, as in fact, in the judgment, they put it to the Commission to provide more clarity on these terms, in essence saying, hold on, if we made a mistake here, could you please elaborate on where we went wrong and how we should have interpreted these economic terms? The fact is, this practice went unquestioned for decades. Later we'll get to why it changed. But at this point, you could say these lawyers were not knowledgeable in economic terms, but instead relying on their own understanding of the law and perhaps even competitive practices from the UK to interpret into European Union law a different understanding of competition. This fact highlights that even if a lawyer was to know economic terms, they might find themselves, in fact, at a distinct disadvantage in understanding European competition law, quite adversely to what you might have believed. If they knew economic concepts, they might be in a better position, certainly, than this. They might be able to think over it and decide why in the European Union, the hotbed of these economic terms, did it go so differently? Anyway, we're still focusing on terms here. So, dominant position was not the only terminology which was changed by European competition law. There was also the terming of undertakings. Now, if you are a lawyer in the United States, undertakings is pretty straightforward. An undertaking, in a non-legal context, could be a promise or an enterprise, but more specifically, you'd think of it as a business entity. And that's where it ends. The EU, over the many years that have gone by, have taken a quite more radical view of what the word undertakings means. And they've taken it from its base humble beginnings that we might find in US law and perhaps elsewhere in the world, and they've changed it into something very different. In fact, you could say it could almost be anything. It includes now people, sports federations, agencies, banks, charities, government bodies, penalties for sports misconduct, franchises, and more. I believe one time they even, in terms of people, it was gymnasts. Now, this is not something you would generally think of as a business. In fact, you'd see them as individuals who perhaps believe that this should be dealt with in a different part of the law. However, in this situation, the European Union felt obligated to factor them into what an undertaking was. Now, this split from the economic term is to the advantage of a lawyer who does not have prior knowledge of economic terms, as they will be as equally out of depth as someone with knowledge of economic terms. In order to understand European competition law, we need to go one step further, as a normal explanation of the words is simply not enough. And that is because of the unique situations in European states and the market interests of the time. So we need to be able to think on our feet as a lawyer. A good example of just this same split I'm discussing is how the European Court of Justice treats the term concerted practice, dominant position, market power, and market share together. One might feel that separate all of these words can be taken in the negative. If you are taking part in a concerted practice, you are working together to get the best results for you and not necessarily the consumer. If you're in a dominant position, you might be repressing competition. If you have market power, very similar to dominant position, you could be using it to influence competition. And equally, if you have a large market share, you might take advantage of that to charge higher prices, knowing full well people will have to come to you and no one else. The way that the ECJ interprets these words together in Articles 101 and 2 should help your understanding of how different they are. Now, for a lawyer aware of those economic terms, they might feel that they automatically, if a company does commit any of these, they automatically fall foul of an infringement of competition law. Yet, the ECJ does not take that to be the case. They only see it as an abuse if there has been an actual situation of abuse, or if they are truly as powerful as is being claimed. Further, if their dominant position actually leads to an improved situation of trade between nations or benefits significantly consumers, then that is to be welcomed and not to be repressed, which is really quite interesting. I believe there was a situation like this in terms of a concerted practice in the European Union where a company in Germany was working with a company in Belgium in order to sell TVs exclusively, and the result of the exclusive deal was a better deal for consumers and for the German product to be able to transcend the one market and in fact go a bit more global, get a bit more closer to what European Union's idea of an interconnected society business was. And in that case, the judges certainly fell in favour of it not being a concerted practice, or at least they recognised it was, but said it was a beneficial one, so it's all right. What this all points to so far is that a lawyer who understands economic terms is no better off than the average lawyer when it comes to understanding how the ECJ makes its decisions. So, how then can a lawyer make sense of European competition law? If knowing the economic terms is no guarantee of understanding the jurisprudence behind them, the answer must lie then actually not too far away from what we would do in the English and Welsh common law system. That is to say, for a lawyer to understand European competition law, they must not look at the economic terms, but they must look at the primary law. They must look at the decisions made by the ECJ, the treaties and regulations in existence. They should also look at the Commission guidance notes, such as the Commission notice, which I believe one is called, and the number of cases decided by the Commission themselves, because ECJ is not the only one deciding the law these days. You should also read the advocate's decision, as that will give a far more broader understanding of what is behind the decisions and a good working knowledge of European history, culture, economics and social heritage is incredibly useful and invaluable for gaining this sort of understanding. Now, while a lawyer who knows economic terms would struggle, a lawyer knowledgeable in economic concepts would be able to understand the purpose of European competition law, and that would enable them to understand how the ECJ was intended to make its decisions. To understand, Europe has been home to a host of economic philosophies. Think Adam Smith with his concept of supply and demand, which understates the process of factory production, which was later built upon by a gentleman called Ricardo's with a concept of comparative advantage, which again looks at the idea that a country should focus its energies on the industries where it has the potential to be superior to others in. Think of it this way. Germany focuses on manufacturing, France focuses on agriculture, the United Kingdom focuses on services, Romania, Bulgaria focus on development because they offer cheap places to set up. So everyone has, in Europe to an extent, their own unique, superior, advantageous, comparatively advantageous area which they choose to work upon. That's as a result of this economic terms. Now, while a knowledge of the economies of Europe would help a lawyer understand the ECJ's decisions in relation to certain industries, so if you operate in the UK, perhaps they will take a more harder line on mergers occurring in the service sector because of the influence that would have on the rest of Europe. But a merger that got you a dominant position, say in Romania for services, obviously doesn't have as great an impact on Europe as it would in the UK. So you might let that go ahead in the belief it actually improved things for those living in Romania. Now, while again this all helps you understand certain industry decisions, it does not always make decisions based on sound economic principles easy to understand. What I mean by this is sometimes there will be decisions which, had you gone along the reasonings of, say, Adam Smith, the case should have gone one way, and in the past perhaps it would have gone that way. However, currently it takes a very different direction. Now, for a lawyer to seeking to understand why this might be the case, why in not every circumstance the pure capitalist idea is championed, one needs to look at some of the other economic concepts that were radiating out of Europe over the last few centuries. Think Karl Marx, think Proudhon, Berlinguer, who did Marx, by the way, is communism. Berlinguer is the idea of anarchism. Lenin, with his Marxist-Leninist theory that led to the USSR. Max Weber, now we've got an American guy here, but again, hugely impactful on this area. Popper, Keynes, whose work led to the idea that government should be more active in the economy, as seen from, in the US, it would be Roosevelt, who put forward Keynesian ideas the first time round, and to an extent Attlee as well was very much Keynesian and a bit Marxist in his ideas of having everything come into the public sector. Now, these theories collectively, when they clashed together, our capitalist ideas of Adam Smith and our Marxist ideas on communism, together they created the welfare system we see today in Europe. From this dual culture and economic heritage arose the works of Hayek, aka the Chicago School, which is all about the idea of ruthless competition or pure market capitalism, which does eventually produce monopolies. Think the terms succeed or go to the wall. That was the idea. The idea was everyone should compete. The best, the strongest, the most flexible, the most innovative, whatever they are, they're willing to do anything to take the competition down, and the last man standing. That's basically what the Chicago School is all about. Obviously, this can be a problem because monopolies, concerted practices, predatory pricing, all these aspects, perfectly reasonable. By the way, if you don't know what predatory pricing is, that's the idea that you are purposefully undercutting your competition, knowing full well the price is not sustainable, just because you want to force your competition into a position where they run into a loss and eventually are forced to close. Think of it a little bit like the USSR and the USA during the Cold War with the build-up of nuclear arms. Reagan at the end really pushed up the Americans' production because he knew the USSR would try to match them, knowing full well the USSR's economy will crumble long before the USA's as a result of this build-up. That's Chicago School. That's Chicago School in effect. You could also see it very readily in the situation of OPEC nations. Now, we've had a number of mini oil crises over the course of this year from 2016 to 2017, where we've seen oil plummet in price and in some cases skyrocket because of the control of the OPEC countries. These are essentially a number of countries which sell oil, banded together, decided to do a concerted practice and set a fixed price, and allowed the impact of that to just ripple across the globe. You could also think of the Iranian oil crisis in the 1980s was very much a result of actions like this, concerted practices that made prices no longer competitive and created massive problems for those involved. Obviously, the big risk as well of the Chicago School is if you get rid of all your competition, then being the only one around, you can start raising your prices and artificially inflate or deflate prices. Again, going back to our idea of predator pricing. With this very real concern comes another type of concept called the Fragments concept, which comes from Germany. That is to prevent monopolies or oligarchies being a group of very powerful business, a monopoly being one very powerful business. They should be prevented from getting too big. And in the process, multiple businesses should exist and be maintained in order to continue this sort of eternal struggle for dominance. And that, as the belief goes, through an eternal struggle, prices will remain at their best. Just imagine if Walmart, I'm looking at an American example here, if Walmart did not have to compete with Costco's and Woolworths and all those people back in the day, all these big cost cutters, would they be as successful? When you read the autobiography of our man who made Walmart, Sam Walton, he basically says, if not for the competition we face in America and what we saw overseas, because they also got some ideas from John Lewis, they would be nowhere near as competitive. So this backs up the idea of Friedman's concept that by having competition around, it drives you to be at your best. Similarly, Friedman also demonstrates this same system right now in the UK. Think of the pricing wars existing between Tesco's, Asda, Waitrose, Marks and Sparks, all of them, and how they are trying to get either quality for less, even Aldi's and Lidl, how they are trying to undercut each other and give the best value to consumers because consumers know how to shop around. You see the exact same situation everywhere, and the idea being, with the Friedman concept, this sort of healthy competition is good for the market, gets you the best prices, gets you the best quality. There is, of course, inherent problems with this. The Friedman concept also means that some companies, in a pursuit of staying competitive, may cut their prices to an unreasonably low level. They might make their quality much poorer from cutting corners, and that means quality does not improve. Although the same problem exists with the Chicago School, where you could be increasing prices but not increasing quality. So the end result can sometimes be the same. Now, when we get to big business, what Friedman is saying is we shouldn't have mergers. We shouldn't have big business mergers. No one should ever get to a situation where they are that dominant. We should always be competing. The flaw, as I identified earlier, is in quality. This is, if you look at the readings of a gentleman called Deming, who is an American economist who worked on quality control, quality analysis, he talks about the idea that actually oligarchies and monopolies are the companies that are in the best position to provide innovation and competitive practice. Think of it as the game of scale. When you're a small business, all your overheads are much bigger because you need to focus it, because you don't have the other links to the other industries, you're buying everything from everyone, and you don't have a large amount of money. When you're a big business, totally different. Your main problems are going to be logistics. However, you will control a larger swath of organisation. Just think of all those farms that Tesco now owns, which are able to provide them with a constant supply of meat, poultry, beef and all the rest of it, and at a much lower price than if they didn't own the farms and were in a situation where they had to negotiate. That dominant position they are in means they can get these products on the shelf. Their ownership of warehouses, their ownership of the department stores, their ownership of so many other industries enables them to give better value for money because they can minimize the costs involved. If you're a small industry, you can't minimize the cost involved. You just simply don't have the money. Also, think about it. What is cheaper for a factory to produce one pen or to mass produce 1,000,000 pens? It's cheaper for them to mass produce 1,000,000 pens, which they can then sell for a fraction of the cost of if they had just produced the one. So think of it in these terms. When you go to buy a pack of pens online, if you want to buy 100, it'll cost you £20. If you want to buy 1,000, it might cost you £40. So you end up getting a lot more for your money. Same applies to monopolies. What Deming was saying is the bigger they are, the bigger the potential to do the right thing. It's just that in the current market, there is this, if you feel, lethargy among big business, where once you get so big, it's no longer about personal innovation, it's more about keeping them down. Just think of this as, in Deming's words, when a company decides to make a product which will fail after the warranty, at that point they're no longer thinking about quality. Anyway, back to where we're meant to be at, okay? So there is another problem, of course, with Friedman, and that's the idea of creating and supporting artificial competition. Remember we were talking about artificial prices? There's also the idea of artificial competition for the consumer. So supporting businesses that really are not sustainable is one of those issues, which has a knock-on impact on the consumer and on the taxpayer, because someone has to come up with the dough to keep these businesses going, and it's often the government who are taking subsidies, in essence, from the taxpayer. By doing this, by not having a monopoly or an oligarchy or big business in a position to generate this worth for the people, prices remain perpetually high. If we just want to do an example, going back to Continental Cans, remember, the judges decided, yes, it was a dominant position, but we're not going to take it as a negative because the merger enabled better value for money, this bigger organization that could then offer lower costs. That's exactly what Deming was getting at, and that's exactly what the judges are getting at in this situation and what we're trying to talk about. Of course, there's also the other risk that with Friedman, if everyone's given a bit of money to keep them going, they will also lose interest in innovating because they don't need to innovate to survive. If you're working to survive, you're not working to thrive. So there's a different situation going on. A business working to survive might give the bare minimum of quality because they know it sells and the money can be reinvested into the industry. A business that's doing incredibly well will be willing to invest more in research and development and will continue to keep growing. What the ECJ is looking for is to create a situation of the latter and not the former. So our thrivers, not our survivors. The risks of Friedman is our idea of protectionism. Obviously, if you want to keep a business going, and we can give the example of the French agricultural industry, they have a massive amount of subsidies given to them from the ECB, the European Bank, basically, every year in order to sustain the French agriculture. Now, the agriculture is needed, but again, it's not very sustainable because of those subsidies. And a protectionism can creep itself in. If you want to keep businesses open, if you want to keep them able to practice, more often than not, you don't want them in a situation where the competition is floating around. You could compare this to Lloyd's UK and how they cannot necessarily act as an independent insurer in the US because they're not set up there, but need to have a sort of subcontract going on with companies like Hiscox, who are a US insurer. This sort of underwriting going on, this subcontracting, enables them to operate in the US, where there's perhaps a more protective bubble around the industries. In Europe, you could compare it in the same way to the earlier laws that existed in countries like Italy, Germany, France, which very stringently protected the service sector from outsiders. There have been a number of cases in the past of UK lawyers travelling to these countries and complaining there are too many restrictions. I think in the case of Italy, one time there was a requirement to be a barrister where you had to have been educated in Italy. So even if you knew the language, even if you could have taken the bar exam there and passed it, you needed to have actually studied there for 4 or 5 years, which is just it's not really conducive to having a globalized European market where you can work anywhere, because protectionism at its worst. Now, we also have to think about Article 106. 106 is more focused on what I've just been discussing, the government protectionism that Hayek would have seen as a risk. Spinning all the way back. From this perspective, a lawyer knowledgeable of Europe's underpinning economic principles in conjunction with European law would be able to predict and understand most EU competition law. Yet one last price or piece is missing, and that is the history and the culture. So even if you understand the economics, you understand all the theories going around and understand the concepts, still some cases might elude you and confuse you. To understand requires a knowledge of the EU's precursor, the League of Nations. This union existed for peace, but it failed to curb the risk of war. It actually dissolved more or less when World War I came to be, and then later World War II made sure League of Nations would not be a thing. What was discovered in this process is treaties and obligation to each other just wasn't enough to create peace. Europe needed to be in a position where it wanted for nothing. So rather than fighting with each other to steal each other's resources, it would be instead better to trade with each other for those same resources. So came the earlier versions of the European Union, such as the European Coal Mining Community, which then became the European Coal Community, the ECC, and then eventually the European Union. But you see, was it Coal and Steel Community? ECSC. Anyway, whatever names it chose to go with, the idea was, through interdependence, you could remove the risk of war and remove the idea of shortages. During this time, the trading blocs arose. So this time period, by the way, that our early stages of the European Union is emerging, you could say is about 1950, because 1951 was when we have the European Charter for Human Rights and the Treaty of Rome, 1951. So our sort of first few starting people, France, Germany, Italy, that eventually became the European Union. When all that was going on, we obviously had the Cold War. There was the USSR, who you could say was using an extreme version of Friedman's idea, because they were sustaining a lot of industries that were no longer competitive, and they ran into their own problems. They were setting unassailable quotas. They weren't realistic. The USA seemingly gone down the Hayek route. They actually sort of moved away from Keynesian and moved more into this idea of Chicago School. So work hard or you go to the wall. And we know that from modern times because of the collapse of the Lehman Brothers, which was the fourth biggest bank in the US up until the moment when it fell during the economic crisis. For that to happen, it requires the Chicago School, and the fallout from that was amazing. What our EU competition lawyers were facing was this shake-up of ideology going on around them. Very much the European Union, the Europe as a whole, was a testing ground for how these two theories battled it out. And in the early 90s, late 1990s, we see the breakaway of the Eastern Bloc, the fall of the Berlin Wall in 1989, and the assimilation of the rest of Europe, you could say, into the west of Europe. This point in time is when our great legal lawyers who were once championing the causes of European competition law start to become co-pilots. Of course, this is a result of the fears of the Commission. The Commission have always had the power in them to start deciding on the law, to start giving out advice to the ECJ. But they had previously chosen to just sit back and let the lawyers decide things. After all, they're best suited, and really, what's the worst that could happen? When they were assimilating the Eastern Bloc, there was a massive fear that many of the countries would continue the same practices that had been uncompetitive while in the USSR, and that this would have a knock-on effect on the rest of Europe. The Commission, afraid of this possibility, acted, and they drew up things like the Commissioner's Notice in 1999, if I'm getting my dates on point. Now, this notice essentially explained a lot of what the judges had already been working on over the years, but it went a step further in defining, in the Commission's view anyway, what a lot of these economic terms mean. And the reason why they did that was in case countries like Romania, like Bulgaria, which they perceived to an extent to be the worst offenders, I'm not to say, just taking a guess here, or perhaps Poland or some others, they thought that there was a big risk these guys would look at what the ECJ had done, would think, it's a bit confusing, let's just go ahead and do this, we've already done it, a lot of this stuff's already in public hands, it shouldn't matter. The Commission, in effect, said it does matter. They set out, these are the sort of steps we want your country to do, and you should make steps towards privatisation. We do not want to find that this has not taken place. Of course, what's interesting is Austria would be one of the few countries that creates a big kerfuffle over these new regulations. But that's for another time to discuss. Just know that the Commission at that point began to really get involved. So now we're starting to get a feel for that idea of history and culture, because we know why in the Eastern Bloc, for example, the ECJ might tread a bit more carefully around the concept of mergers, or at least would contemplate whether there is a much higher risk of this dominant position abuse because of the country's history and pre-existing laws that might have allowed it to transpire. Just the fact that one of the countries, I believe it was Bulgaria, in some of their industries oligarchies did exist, and this was sort of smashed to pieces once they joined the European Union. But it was certainly something that these commissioners would have been thinking about and were contemplating with fear. Many of the points that had been reiterated in court related to terms like market power, because in the courtroom, obviously, they would have been less worried about the creation of dominant positions, as they knew most of the time they would have a benefit for consumers. They were more concerned with how they chose to use it, whereas in Romania the concern might have been the creation in the first place because of these past practices, and whether they can prove that such negative practices will not be the norm again. So let's just think again, the courtrooms came up with the idea of a suitable substitute product. Think of it in this term. Does water compete with coffee? Maybe, probably not. Water is really its own standalone product. It's still a drink, so in the broad market it's there, but water is taken straight from the source. Doesn't go through any refinement processes. It doesn't tend to get imported, so water being cheaper is acceptable. Whereas if we were to compare coffee and tea, now that is something you can suitably substitute. They're both hot beverages. They both go through a process to produce them. Coffee beans are ground down. Tea is sort of left out in the sun and allowed to dry and then ground down. So both of them go through a process. They're very similar products. And that's why you find they are often quite similarly priced. You couldn't, for example, see tea going for 20p and coffee going for £1.60. European competition law would just say that's not realistic, because tea will just outsell coffee easily. They need to be a bit more closer in line, so maybe 10p difference or something more based on the quality of the product rather than just they are different. We also see the Commission and the Court focusing really on this idea of a concerted practice for businesses of a certain share of the market, and how the positive impact of that type of work when in relation to higher condemning, so how concerted practices actually produce better quality. You're able to see how this is an exemption to the anti-competition practices. To put it in even greater perspective, there's been a couple of cases. Viho case, which involved the trade of Parker pens. Parker only sold its pen to certain distributors. Another company was buying the pens from Parker and was complaining about the higher price they were receiving than the sort of exclusive pen companies. I believe in this situation, obviously it's Viho pens or something, Viho distributors. Parker turned around and said, no, we reserve the right to have these sort of exclusive trade deals with these certain companies, because we can ensure that they will sell our pens with the same level of quality and standards that we adhere to. And when the European Union, the ECJ, looked at this case, they wholeheartedly agreed, yes, Parker pens deserves a right. Now, the reason why they said Parker pens deserves this right was, you have to remember, Viho had made a case not necessarily on the idea of concerted practices, which might full well have won them the case, but they made one on the concept of a dominant position. In their opinion, Parker pens had a dominant position in the market of luxury pens, and so if Viho could not contract with them, that would greatly impact their own ability to operate as a office supplies, pen sales company, whatever they might have been. What the court decided was that Parker pens should be recognised not in the market of the luxury pen, but in the market of pens in general. They merely said one could have chose a biro and still gotten the job done. So in anything, Parker pen, as part of that industry, the big industry of all pens, they're only a small 5%. So whatever they choose to do, it's not they're not in a position basically where they're dominant enough to make the sort of impact Viho was trying to claim. So they got away with that case. So yeah, Parker Pen won the Viho case. You can compare this, in fact, to the BMW Belgium case, which went very differently. Again, this was a situation where BMW had been giving specific instruction and selling its cars to very specific car industries. I think there was a situation where information was being holed up in the headquarters or in certain BMW distributors. Only they knew what was going on. What happened in that case was BMW were found, I believe, to have operated a concerted practice, and because of the impact of BMWs on the market, it was decided that they should be a bit more transparent. I think share around information. I'm a bit vague on the details. I know it didn't go the same way as Viho did, but they didn't entirely cave in. I think they still maintain the right to have certain distributors sell their cars, because they said in that case they were a luxury good, and yes, they had quite a dominant position in the luxury car manufacturing industry, but to protect that position, to protect the quality of their goods, they should be allowed to pick the distributors and the information they provide. It was decided that the information needed to be freed up more, but that the distribution chain was perfectly fine. It was something to that effect. You're going to have to double check. I'm not entirely sure of the facts on that one. It wasn't the most clear-cut case. It was like it was almost as if BMW had won and lost at the same time. They didn't get the whole package of what they were going for at any rate. And that seems to be the way of European competition law. You never quite get what you came in with. You walk away with whatever they give you. This actually reminds me of the Sulkier case, which was one of a very clear dominant position, very clear protectionist policies, everything suggested foul play, basically. It was clear that the practices going on were anti-competitive in the sugar market. However, as the Advocate General explains, there was in fact a historical context, a historical reason for just this occurring. In his own words, he starts to talk about the Napoleonic Wars of all things, and spoke about how the blockades that existed that Napoleon put up had this massive impact upon the position of sugar imports in the country and affected their crop growing and lots of other things. The end result was that it became uncompetitive to grow sugar in Europe. However, sugar was a staple of the diet and still is. So the European Union had to allow this dominant concerted practice, this very clear violation of competition law, which they knew was not a very competitive price, because in this situation it was to protect the market and the consumer, so that they are not held at the ransom of sugar distributors outside, and to maintain the industries which provided work to thousands of people across Europe. So that if you knew that, you would know the European Union, the ECJ, their jurisprudence is not always about the economics, it's also about the consumer and about the people. And if the consumer loses his job, then you're not really doing the absolute best to do your job, in essence. Now, there's a number of cases that came later. I forgot to mention, by the way, one of the ways that the term undertaking had been changed is so that it meant economic activity. It's like the idea of when the EU provides a statement, a public body is anything that does a public function. It's just so much more broader than if you just said a business or an enterprise. Because anything that does an economic activity, literally, if money is being exchanged, if a transaction is occurring, if there is some benefit financially or economically for someone, then an economic activity is occurring. And that is why so many different distinct categories fell into that revised meaning. Now, when we start to look at the Lisbon Treaty and the Copenhagen criterial requirements, there's a real understanding of, again, the jurisprudence of EU competition law. The Copenhagen criteria, this flows back to my conversation about the laws that were put in place to prevent possible infringement in Eastern Europe. Now, these were put in to make most new industries, new countries joining, majorly privatized, with the undertakings leading the economies and not the nation. So think of the idea that a lot of these countries in Eastern Europe have been led by the 5-year plan. The government sets, this is our agenda, this is where we're going. What the EU wanted was business to set the agenda, for companies to go out their way and go, okay, let's innovate, this product's new, let's put it out there, let's get some work together on it. It's slightly more flexible than if government is dictating. That's essentially what the aim of the Copenhagen criteria in the Lisbon Treaty was, and that is what Article 101 and 102 are trying to protect, this flexibility, this ability to be competitive as a market. Now, I've made a couple of conclusions here on this topic, but we'll talk about some of the cases first that didn't quite get the mention perhaps they deserved. Now, despite the sources of the results and the role still being the same, markets and market power are the dominant concepts which exist in the jurisprudence of EU law. Yet, this same understanding of law can be, at times, unpredictable, as can be seen in the cases of Constant and Langenese Igalo. These are two cases that came out really quite recently. Well, not Constant and Legalese, a bit more closer. Constant was early mid-60s, and Langenese was 1995. So not too recent, but you'll see the difference soon enough. The former case, the Constant case, it related to electrical distribution chain. It related to the suppliers. The case found in favour of the existence of concerted practices, yet when it was viewed on the evidence, the affiliation had enabled more competition with such, and given they had such a small share of the relevant market, it was seen as inconsequential. What this case means is, say I am an estate agent in one borough of London. I could merge with all the other estate agents in that one borough of London, and then merge with an estate agent in France that was in one small constituency. Now, it's clear I have dominance of my market and probably their market. It's also clear there's probably a concerted practice going on between us, maybe to get the same sort of prices for the houses in that area. What the ECJ would say is, yes, we see concerted practice taking place. Yes, there is a dominant position held. However, on the facts, they are too small to have a massive impact on Europe's economy. By the way, the reason why I say they have to be Britain and France intertraining is because there is no breach of EU law if the infringement occurs in one nation state within Europe. So if all these dodgy practices are going on just in France and has absolutely zero impact on its outsiders, and no one outside is trying to get in, then it is French law that deals with that problem. It is not European law. With that being said, this demonstration of market share in the circumstances comes up again later. It's interesting to contemplate how the scale of SMEs and how them using concerted practice in the situation of, for example, franchises is actually seen as a positive and an essential to doing business and for them to expand into new markets. However, if you look at the Chicago approach, the reverse practice might enter the big stage. When you get much, much bigger. Doing these sort of practices that would have been essential when you were smaller now create a massive vulnerability to EU competition law once you have become big. It's essentially Chicago School runs the operations for small, medium-sized enterprises, or SMEs. Fragments comes into effect when you become the big heavyweights of the industry. Now, when you start to read about the Advocate General and the language he uses, it's clear that economic language alone will not suffice for your court rulings. I've already spoken about Sonkier, so we don't need to go back to that, which was a case of sugar distribution between Germany and the Netherlands. I've also spoken about Viho. Don't need to go back to that. BMW Belgium. Do not need to go back to that. BMW Belgium being about chains pricing and how car is cheaper in one country and more expensive in another. That's what I forgot to mention. I do apologise. Now I have. As it is quite clear from these cases, there is a big concern over the economic terminology and what is an undertaking. Hang on. I don't know where I put my back page. Here we are. Thank you for bearing with me. Courts take a different approach to the use of terms on the basis when compared to ordinary meaning. With that said, if you can understand the economic terms, it helps to give you an idea. If you understand the concepts, it makes everything a hell of a lot more clearer. If you can understand competitive practices in general, you're really flying. And if you want to be a co-pilot, you need to understand modern competition law, because economic terms alone will not help you. Now I'm just going to fly back to some of the other workings I've done on this, so we can round this off nice and easy. So what I'm trying to say here is if you have prior knowledge of economic terminology, you might run into problems understanding EU law. If you come with an empty slate, an open mind, or at least see the view that European law, while being potentially influenced by economic terms, is not at all restricted by them and is a big blank book. You could say the persuasive elements make up some of the footnotes. It's something they've considered. However, EU law, competition law, is its own beast. And if you want to truly understand the jurisprudence, economic terms is not enough. The question of can a common lawyer understand the jurisprudence of EU law? If looking at it from the outside without any involvement, the answer is obviously no. If they are willing, however, to go in, to stick their hands in, to get stuck in with EU law, like we have just done now, to understand the history, the culture, some of those landmark cases, some of the cases behind it, to read into the Commission, to get a full understanding of everything involved. Those types of lawyers, irrelevant of their background and whether they studied economics or not, they will fully understand European competition law jurisprudence. And that is essentially my conclusion. If you are going into this area of practice, if you want to study more about EU competition law, it's probably a good idea, like Wish and Bailey said, to look at the concepts. If anything, it will at least have you thinking like an economist, which is good because the Commission is built up of economists, not lawyers. And they seem to be making half the laws these days. When you're practicing, you might just find yourself trying to translate the meaning of some of those same words they have said. But if you want to understand the jurisprudence in its totality, just like the UK common law, you're going to need to understand people involved, the history of the nation, the background of those same cases, and really make it your own. I personally do not feel it is possible to ever fully comprehend something. But to the sufficient level of a practitioner, there are these steps I've discussed that you could take to be just as successful. that's my answer to the question. I hope you now understand how knowing just the economic terms as a lawyer doesn't necessarily give you full understanding of the jurisprudence of EU competition law, and how it does require a lot more than that. If you're willing to stay on a little longer, I do have a full list of my bibliography of what was referenced in this work. Now, I didn't always mention the cases. I often spoke about principles without directly mentioning cases that were used. That's because I don't want you to go away with your head in the clouds thinking, oh, there's this hundreds of cases and facts and references. If you want to look at the article itself, I've tweaked it a bit in this discussion to make it a bit more understandable. I personally feel that has made a massive difference. There are some things I can say here that I just couldn't say because of word limits in the document itself, but I'm going to put it up on a Dropbox with this article later on in the month, along with some of the older ones. I'm just going to read to you my bibliography so you know in advance, in case you need information now and not later, so that you know that this really has been quite heavily researched. Now, hold on for a second and I'll just grab it. Okay, I'm back. So here they are. Keep in mind, this is not an exhaustive list. This is dated to 2017. Give me a moment to think. Probably April. That's the cutoff point. So any information that's come from then to now would, of course, change your reasoning. I do implore you to keep as up to date as possible. There's no doubt many cases I've missed. Just from a quick search, I know there's at least 100 European cases on just this area, and no doubt some of the judges had some very enlightened things to say. I only managed to get through a handful, as well as journals, in the time available to me. But here's some of the things that were looked at in my commission paper. The first was from the Commission's papers, the opinion of the Advocate General, Roemer, spelled Roemer, in Continental Can, delivered on the 21st of November 1972. This was available on page 254. I also read the Commission Notice 97/C 372/03 on their definition of the relevant market. Newspapers I looked at the BBC article, EU Budget, How the Money is Spent. That was released in 2017 to give me an idea of how the development fund was split across industries like agriculture, services, and so on and so forth. Dictionary-wise, I looked at the Bix Bryan, A Dictionary of Legal Theory, which was released in 2004. I also looked at the Dictionary Nobel, Joseph and Dilly Parkinson's editions. Oxford Business English Dictionary for Learners of English, Oxford University Press, 2005. Again, these two dictionaries, a bit dated, but generally speaking, the terminology hasn't changed at all in terms of the broader understanding in this 10 or 12 or 13 years. So it was just basically the same. Books I've read is the book by Tibor Ivan Berand. This is called From the Soviet Bloc to the European Union, the Economic and Social Transition of Central and Eastern Europe since 1973, Cambridge University, 2009. Just so you know, for a little bit of context on that specific book, the reason why the European Union was more than happy to allow the Eastern Bloc in was because it meant that all those countries that sat on the peripheral, that sat in the centre between Western Europe and Eastern Europe, who were perhaps closer in tune with Western ideals, but if they had joined would have affected the neutrality and the risk of war in the region. This book discusses the reasons and what came from those centralized countries joining. So think of Austria, Hungary, these sorts of nations. They were very much in the center of Europe during the Cold War, during the Iron Curtain. They had to remain neutral, so they didn't join the Eastern Bloc, they didn't join the European Union. When things fell apart, they did join the European Union because there was no longer this threat of war. Similarly, the Eastern Bloc was swept up in this as a way of preventing them falling into decay, and that spreading to Europe. This book covers that. I also read the Peter J. Buckley and Mark Casson, The Future of Multinational Enterprise, published by Springer, 2016. I read C. Kasian and D. Turner, Antitrust Policy, An Economic and Legal Analysis. This came out in 1959, so real old school here. I've read E. Mason, Economic Concentration and the Monopoly Problem, 1964. So again, this is focusing on our issues of monopoly. I've read James Friedman, Oligopoly Theory. This is from his Handbook of Mathematical Economics 2, released 1982, pages 491 to 534. I've read Friedrich August Hayek's Capitalism and the Historians. This was released by Routledge, 2013. I've read Jane Jacobs' The Economy of Cities, Vintage, were the publishers here, 2016. I've read John Maynard Keyes, a big man here on this name, his Means to Prosperity, which was released in 1933, so really going back to the origins of that ideology. I've read Paul Krugman's The Great Unravelling, Losing Our Way in the New Century, which was released by W. Norton and Company in 2004. I've read David Lanz's The Unbound Prometheus, Technological Change and Industrial Development in Western Europe from 1750 to present. So covers really a massive spring here. This is what we meant by the history context. That was released by the Cambridge University Press in 2003. I've read Vladimir Ilyich Lenin's Left Wing, Communism and Infantile Disorder, released by Resistant Books 1999. This is again to understand where Lenin's theory differed from earlier communism and Marx. I've read Hugh MacLeod and Werner Ustaff's editions of The Decline of Christendom in Western Europe, 1750 to 2000, Cambridge University Press, 2003. Again, you'll notice the law has been largely affected by moral decisions, and a lot of that came from Christian virtues. With the shift from Christianity to our sort of atheism and Renaissance period ideologies of science, came this pulling of the old Christian morals into the New Age. That's what this book discusses and how it's impacted upon some of those court decisions. I've read R. Gillette, Monopolization and Abuse of Dominant Position. This was released by the Martinus Nigeros, 1970s. The pages were 750 to 751. I've read Jeremy Shearer, The Political Thought of Karl Popper, Routledge, 2002. Karl Popper's original works, Karl Popper being German, were not the easiest to get a hold of. This is another author's writing about his theory. I've read Adam Smith, Wealth of Nations, re-released by the University of Chicago bookstore in 2005. The Economics of Antitrust Laws in B. Bucart and G. de Geest, Encyclopedia of Law and Economics. This is Cheltenham Ilgard 2000, volume 3, page 473, as well as J. Fall and Nick Pay, The EC Law of Competition, OUP, 2nd edition 2007. I've read Max Weber, The Protestant Ethic and the Spirit of Capitalism, The Other Writings, Penguin 2002, Wish and Bailey Competition Law, Oxford University Press, 2015. Just so you know, I'm just going to go through my secondary sources before going through the primary, a bit reverse order here, because the primary sources, this is an Oscola-styled reference, so my primaries were kept in the footnotes and not transferred over to the bibliography. The journals I read was Aradina, Philip and Donald F. Turner, Predatory Pricing and Related Practices under Section 2 of the Sherman Act, Harvard Law Review, 1975, 697-733. I've read Assenlim's Bellingeri's Le Accage de l'Or, 1848. and it was quite difficult reading French when you are not a Frenchman, but we all manage. I've read Oliver Blanchard's The Economic Future of Europe, the Journal of Economic Perspectives, 18.4, released 2004, pages 3 to 26. I've read Andrew Gligg and Martin Battershil, Quality Farm Food in Europe, a possible alternative to industrialized food market and to current anti-environmental policies. Lessons from France. This is from the Food Policy 1998. I've read Andrew Haldane and Simon Brennan and Veselés Maduros. What is the contribution of the financial sector, miracle or mirage? The Future of Finance, 87, released 2010. I've read James Hamilton's Oil and the Macroeconomy Since World War II. This is from the Journal of Political Economy, 1983. I've read Kisha, Guo, on newly leading industries in the new period of industrialization in China. China's industrial economy. This was when, in my article, I did not expressly refer to it here. I went into a lot of detail about China's labor system and how that compares to the US and Europe in this context and these EU laws. I read Robert Mabrow, OPEC and the Price of Oil. This is from the Energy Journal, 1992. I've read Karl Marx, Friedrich Engels and Samuel Moore's The Communist Manifesto. Speaks for itself, re-released 1959. I've read John Mearsheimer, Back to the Future, Instability in Europe After Cold War. This is from the International Securities, 1990. I've read Domenico Marionetti, Perestroika, The Transition from Central Planning to Market Socialism, Economic Policy, 1988. By looking at Perestroika, I got more of an idea of the difference in the practices between Russia, Europe, and America. Well, I have read Andrea P. and D. Turner's Predatory Pricing Practices under Section 2 of the Sherman Acts. Different page though, 697 this time. I've also read Michael Potter, his Refusal to Supply and Innovation, Past, Present and Future, that was released in 2010. I've read Pierre Joseph's Proudhon's System of Economic Contradictions, or the Philosophy of Misery. This was released in 1888. I've read Lord Reed, The Judge as Lawmaker, The Judicial Public Teachers of Law, 1972. Keep in mind, of course, that Judge as Lawmaker was used in reference to how lawyers are leading the way, and indeed judges, in the creation of the law. I've read Gary Sampson's and Alexander Yates, An Evaluation of the Common Agricultural Policy as a Barrier Facing Agricultural Exports to the European Economic Community, American Journal of Agricultural Economics, 1977. Now, if you'll bear with me, I will get up our long list of cases, and it is long. Well, would you look at that? I just found one of my missing pages when I was looking for the references, and it actually goes over a little bit more about some of those same terms that we missed out on, such as hegemony. It also looked at cases like United Brands, which was about bananas, and some very similar cases like Anzo, Hugin, Spar, Eurofix, Tetra Pak, Hoffman, Michelin, BP, Microsoft, Gottschalk, Sakim, Glassmith, Boozy, and Rody, as well as others. These are all cases about dominant positions, and in some cases there were fines, in other cases nothing was done, in some cases different decisions were made. These are all, like Microsoft especially, it was something about monopolization of the industry because everyone has to use Office these days, or everyone uses Windows to log in, apart from if you have a Mac. They're just cases like that. You could even compare it to the recent case where Google was fined because they didn't make it easy enough for people to use other search engines. It was just like, this is Google. About 90% of people use Google. No one else uses Google. We don't recommend you to use Internet Explorer or anything like that. It's something like the EU said they need to make it easier for people to use more than just Google. Anyway, all those cases I previously said relate to dominant position. The Google case, the very recent one, I'm certain that case was decided after this essay was written. So give that a look. That's a 2017 case. That was to do with the Commission sanctioning Google. It wasn't precisely a case decided in court, but most certainly it is on the issue of Article 101 and 102. And if you read through it, it will give you a great understanding of both articles. Now, I'm just going to go quickly through all of the cases that were used today. So, thinking caps on, listening caps away. Actually, put those listening caps back on. You're about to hear a lot of cases. So we have, I'm not going to say I will say the full case. They're long. Bear with me. Case 5/69, Volk and Can, 1969, ECR 295. Lucas. So yeah, here are all those cases. We have Lucas brackets Save Diggle Action Group close brackets, as well as R open brackets on the application of close brackets, and Oldham Metropolitan Borough Council 2017 EWH C349. That's from the first page. Next we have Council Regulation EC number 1/2003. We have obviously the Treaty of the European Union, Articles 101 and 102. We have Case 6/72, Europe Belgium Corp and Continental Can Co. Inc. and Commission 1973 ECR 215. Paragraph 26. There is the hold on. Case T-319/99 Federicon Nacional de Empresas de Instrumentos Científica Médica Técnica y Dental Fenin and Commission of the European Communities 2003 ECR 50. Now we've got some commissioner cases here, so they might be a bit odd. IV/96.559 Re Unitel 1978 OJL 157. IV/33.384 and IV/33.378 Re World Cup 1990 Package Tours 1992 OJL 326. Basically, these cases were decided together. Case 71/74 Frubo and Commission and Veragini di Frutini 1975 ECR 563. Case 209/78 to 215/78 and 218/78 Van Laderick and others and Commission 1980 ECR 3125. This is joined by the joined cases 96/82 etc. IAZ and others and Commission 1983 ECR 3369. Case C-172/80 Zuckner and Bayerschicht Verein Bank 1981 ECJ 14. Case C-222/04 Ministerio dell'Economica e delle Finanze vi Casa di Risparmio di Firenze SPA and others 2006 ECR 8. Italian State and Sachi C as well as C-41/90 Hofer and Macrorin 1991 ECR 161. Case C-519/04P Mecca Medina and Majshin and Commission ECR 492. Case 161/84 Pronumptia di Paris GmbH and Pronumptia di Paris Irmgard Schillingis ECR 353. Case 56/65 Society Technique Ministère and Mashibuku GmbH ECR 8038. Case C/8/08 T-Mobile Netherlands BV KPN Mobile NV Orange Nederland NV Vodafone Libertel NV and Rad van Bristol van der Nederlandes Redingassertoruk 2009 ECR 343. Hold on. Still get okay. That's that page done. Just keep going. What do we see? Nothing on that page. That's the philosophy page. What do we have on this page? Nothing on this page either. Still philosophy. Here we go. Case T-51/89 Tetra Pak Rusings SA and Commission Tetra Pak I, it says in brackets. 1990 ECR 2-309. Keep in mind there's multiple Tetra Pak cases, so you'd need to be specific which one. That's that for that page. We then have obviously the commission notice. The full commission notice is put as Commission Notice 97/C 372/03 Definition of Relevant Market. Commission Regulation EU in brackets number 330/2010 of April 2010 on the application of Article 101 brackets 3 of the Treaty of the Function of the European Union to categories of vertical agreement and concerted practices. Then we have cases 40 to 48, 50, 54 to 56, 101, 113, and 114/73 Cooperative Vereniging Sukia Uni UA and others, and Commission 1975. Oh, almost there, almost there. We have case T-102/92 Viho Europe BV and Commission of the European Communities 1995 ECR 405 cases 32/78 and 36/82/78 BMW Belgium SA et al. And Commission ECR 1979 2435. We also have case C-89 104 114 116 to 7 and 125 to 9/85 Alahothrom and Com Re Wood Pulp 1988 447. Wow, we've got case 56 and 58/64 establishments Consten Sarl and Grundit Verkofs GmbH and Commission of the European Economic Community 1966-41. We have case T-7/93 Laganese Iklo GmbH and Commission of the European Communities 1995, this is 98. Case 23/67 SA Brasserie de Hachot and Consorts Wilken Jacine number 7 1967 ECR 407. We're almost at the end. We've got about 10 more cases to go here. Case 27/76 United Brands Company and United Brands Continental BV and Commission 1978 ECR 207. Case C-62/86 Anzo Chemi v BV and Commission of the European Communities 1991 ECR. Case 22/78 Huggins Krasagazi AB and Huggins Cash Registers Limited and Commission 1979 ECR 1869. Case 6 and 7/73 Istituto Chemitipico Italiano SPA and Continental Commercial Solvents Corporation and Commission 1974 ECR 223. IV/30.787 and 31.488 Eurofix Baco and Hilti OJ 1988 L65/19. Case 2T/51/89 Tetra Pak Rousings SA and Commission Tetra Pak 1 1990 ECR 2309. Case 85/76 Hoffman LaRoche and Co AG and Commission 1979 ECR 461. Case 3222/81 NV Netherlands Brandon Indust Michelin and Commission Michelin 1 1983 ECR 3461. Case 77/77 Benzentine N Petrol Handelsskapsi BV and others and Commission BP 1978 ECR 1513. Case T201/04 Microsoft Corp and Commission 2007 ECR 23601. Case C-250/92 Gottrup, Klim and DLG 1994 ECR 156141. Case C-222/79 Greenwich Film Production and Sachem. C-468/06 to C-478/06 Sot Lesos Case Say EE and others, and Glasgow Smith Klein 2008 ECR 17139. IV 32.279 BBL Boosbury and Hawks Interim Measures OJ 1987 L28636. Then we finally have 94/119/EC Port of Rodbury OJ 1994 L55/52. And that, my dear friends, is our case list. Thank you for listening, for giving me a reason to sit down and talk about the law and these questions. And please take away from this as much as you can, use as much as you can. The law is for sharing. We should all know the law, and we should all be trying our best to understand each other. I believe in that. You believe in that. All I ask is that you share what you find with others, as I have shared with you today. I think I will now apologise for the time it's taken between my last upload and this one. I did go on holiday for a short period, and it took a little bit of time to come back and adjust. I've now come back, I've now adjusted, and you are now, having just heard the last recording, going to be ready. I should be working as normal come next week as well. Thank you. I hope to see you back next week.